Separation and divorce have long been framed as chaotic, combative, and emotionally devastating. But what if there was another way? Today I'm joined by Cassandra Kalpaxis, a family and fertility lawyer, mediator, and the founder of Kalpaxis Legal, a boutique firm known for helping people navigate separation with dignity and compassion. She's the author of the #1 Amazon bestseller Dignified Divorce and the creator of Australia's first ever divorce retreat, Detox Your Divorce, taking a holistic approach to help people untangle their relationships with confidence and care. From conscious uncoupling to modern co-parenting strategies and solutions for shared pets, finances, and even custody of pets, we explore what separation actually looks like in 2025, why co-parenting doesn't have to mean conflict, creative solutions for managing shared homes, finances, and pets, and what Cassandra wants every person to know before they start the separation process. Whether you're in the thick of a breakup, supporting a friend, or just curious about how family structures are evolving, this conversation is full of insight, support, and real world tools to help you navigate this transition with confidence. Let's get into it. Cassandra, welcome to the podcast. Thank you so much for coming on.
Thank you for having me. I'm really excited to chat today.
So I work as a doctor and I see a lot of patients and friends and family navigating relationships ending. And I think it's something that's thankfully being talked about a lot more often than it used to be. But I'd love to just be able to pick your brain and for our listeners to be able to really learn from the mistakes that you've seen other clients make so that they can perhaps navigate this in a much more gentle way. Because, of course, they do say that relationships ending are these major life events. They tend to be very traumatic. People will say, it's one of the worst things that ever happened to them and that it can take them years to come out the other side. And there's definitely now a moment or a movement saying that it doesn't actually have to be this way. And although she was sort of, kind of slagged off a bit for it, Gwyneth Paltrow and Chris Martin had their conscious uncoupling. And although everyone thought that it was all very woke and all a bit strange, it does sound like or look like that they've managed to navigate things. So I suppose where I'd love to start is how can relationships be uncoupled and it not end up, as a 5-year sojourn through the family court system, spending hundreds of thousands of dollars and, everybody hating each other. How can people move forward and it not look like that?
I think that's a really great question. And I think I'm seeing a lot more of this consciously uncoupling more these days than I am the acrimonious dispute. But I think the really important thing that people need to understand when they're separating is it is a journey for both parties. And approaching that with empathy is absolutely important. And people often confuse sympathy and empathy. They're very two different things. And being able to just reflect back on the time when you did love one another, that you did commit your lives to each other, that level of respect that came at that point in time needs to travel with you during your separation. And understanding that you're not going to agree on everything, and that's completely fine. But approaching those disagreements with respect, with dignity, being able to put in place measures to ensure that when those disagreements arise, that you bring in third-party people who can help you navigate them and try and find that happy medium that everyone needs to move on is absolutely crucial. And most of those people never see the family court. And when they hit that little roadblock, they might come to me and say, look, we agree on 500 things. There's 3 things that we don't agree on. Can you help us? And really, my job is to then problem solve for them and say, okay, here are all the different ways that I can think that we can deal with that. And these are all the different things that we can do to make sure you never end up in the family court. So it's really being human. And that's what people forget is they forget to be human as part of their separation.
And do you think it's possible to have a conscious uncoupling if one party is blindsided or completely shocked by this relationship ending? Because it sort of seems possible if you have a couple who've really made a very mutual decision together. They've perhaps just grown apart and they're still very good friends, etc., etc. That sort of makes sense. But whenever you've got perhaps where maybe there's a third party involved, or someone's been very much blindsided by the end of a relationship, have you seen that be able to move forward as well?
Yes, but the person who has grieved the relationship during the relationship, by the time that the separation has happened, they're ready to go. They're on a pathway to be able to transition forward. The other person who is blindsided needs a lot more legwork. So that's the person who we're generally making sure that they're seeing a psychologist as part of their separation journey. They're seeing a mediator who can come in and be able to make sure that we're able to drive the conversation forward, but in a way that is also very kind and deals with the grief of a relationship that they are just only at the beginning of that process for. So it's possible, but also you need the person to be in the right headspace to do that. And if they're still navigating the grief cycle, which we know can happen over the course of many years where they're angry and they're confused and they're upset, and we have to go through that journey multiple times, it can make that really difficult when we don't have the right people in the room for that person. So, yes, but making sure that we do the work along the way is absolutely essential to making sure we get those people in the right model.
Yeah, I had a gentleman I was dealing with recently as part of a family that I know very well. And and it was interesting his take on being kind or compassionate to his ex-wife was that he didn't want to give her any hope of a reconciliation. And therefore he was being really very I felt very rough and brutal in his approach to her. And there was absolutely no doubt that she was in a different phase than he was. But, have you come across that situation?
Absolutely. All the time. And sometimes it takes somebody else to read through that correspondence and tell that person there is a way that you can convey that there is no reconciliation, but you need to understand that your language, your tone, the way that that is being perceived by the other person is very different to what you intend. And sometimes you deal with a person who it's a characteristic of their personality where they say, "Oh, no, this is just me. That's how I talk." And that's really what I need to bring in some other people into the space to unpack that. It also feeds into that theory of love language. The way that you feel love is not the way that the other person receives love. And that's also the same with communication in a separation. The way that you communicate with someone is not necessarily the way they're receiving it. And communication is the biggest part of how a situation can unravel really quickly, particularly in the amicable divorce space. Sometimes it's not what you say, it's sometimes what you don't say, or it's the silence, and all of that can feed into it. So, yes, we definitely have seen that. And it's very tricky to navigate when I have somebody who's dead fast in the same pool of I'm not changing my ways. This is how it is, and this is how I'll communicate, particularly when you've got another party who's on the receiving end of that.
Cassandra, I work with a lot of peri and postmenopausal women. That's kind of my group of women that I really enjoy working with. But they're definitely a group of women who seem to be navigating a disproportionate number of relationship breakdowns, sometimes from very long relationships. And sometimes it's something that they've initiated because they've got to the end of the road in a relationship, but also it can be that they're navigating health issues themselves, perhaps intimacy issues are all impacting on a relationship. Um, is that an age group that you also see a disproportionate number of clients coming from?
It's actually a large portion of my practice at the moment. And there is a part of me that loves working with that women because there is something really beautiful about that stage of your life as a woman where for some people, your tolerance to what you previously were able to endure in a marriage is no longer there. And it's a very freeing and liberating moment where it's almost that light bulb that goes off where they're like, I'm not doing this anymore. This stage of my life is no longer about service to everybody else, and I'm prioritizing myself. And those women, when they come in, are fantastic to work with because for once in their life, it is about them. And it is an incredible thing to witness. And then off the back of that, those who are going through those really difficult health issues that arise when you're in that stage of your life and those impacts that it has on a relationship, is difficult to manage, particularly when you have a partner who doesn't understand what that person is going through from a psychological perspective and from a physical perspective. And often, what we do when we get to that stage is we actually bring in health experts into the legal space. And we do that through something known as collaborative practice, where instead of that person coming in and just talking to one party, that medical information becomes shared information and the experts get to talk about actually what is going on. And sometimes it takes that third party to come in to explain the process for the other person to go, oh my goodness, I get it. And then we can all brainstorm and strategize things that can be put in place to either A, salvage the relationship, or B, if the relationship is actually over, how we can do that in a way that still honors what's going on in the room from a health perspective, but also allows the transition of the separation to take place quickly.
And do you feel like what would be the ideal first steps for people who are navigating a relationship breakdown? Like, do you think it is important to always involve a lawyer, or do you feel that people can navigate through the whole thing without that? Or
I think it's important that people get legal advice to understand A, what they're entitled to, and B, how the process works. For some people, I never see them after that. They're able to do things themselves. They can navigate the process really simply. They are really good with their finances, so they're able to understand what they have to separate. They're really great parents. They've prioritized their kids. There's no need for there to be any legal involvement whatsoever. For women who have been in a situation, particularly who have never understood the finances, have no idea where their money is, how it's being spent, what their mortgage might be a month, those are the people who absolutely need to have a lawyer involved in their separation because they might have been in a situation where they are being made offers. And I often see this, and those offers are really based on information that they don't have. So how could you possibly know if you're getting a good end of the deal when you don't know what the deal was made up of to start off with? So having that extra level of protection around the legal process for those women is absolutely crucial. And for some other people, I see them on the other end where they've done all the legwork and they come in with the agreement and they say, we just want you to check over the agreement. Can you tell us what might be missing? Can you tell us what else we might need? And those people are people that I might help for a little while to be able to get things right so that the agreement is done properly. And I never see them. But I think it's different, understanding the different levels of where your relationship is at, where you're at in terms of the information that you need to make decisions, that helps people to understand our role in a separation.
And I know that we can't talk about specifics, or because it's very, very nuanced and very individual. Um, a lot of our audience are Australia based, and then we do have a lot of audience overseas as well. So obviously there's very jurisdictional differences. Like, one of the things I noticed when I first moved from the UK to Australia was the whole 50-50 parenting arrangement. That was not something that I saw very often in the UK or in Northern Ireland where I lived. But it's very, very common here in Australia, where the kids are sort of splitting their time between the two parents. Can you talk a little bit about that and where that is at the minute for anyone listening, whether they've got younger kids or teenagers? How does that all work?
So, with these new amendments that have happened in June of this year under the Family Law Act, this whole 50-50 thing is pretty much out the window. So where we're starting from now is it's nuanced. It's on the individual needs of the family, what's going on with the parents, what's going on with the children, what their previous relationship was like with the children, and how do we communicate in order to determine whether or not that arrangement should be in a week about or weekends or split during the week. And it's really a process now of when people come in, we ask them very guided, specific questions to be able to get to that, and it's fragmented. So we don't generally want people coming in and saying, we know what we want to do until these children are 18 when they're 2, because you can't possibly know what you're going to want to do when these children are 10 because they've never been 10 and you don't know what that's going to look like. So there are some families, for example, that we have things in place for 3 years or 5 years, and then after that we revisit. There are some people who, because of their partner, are never going to be in a position where it would be appropriate for time to take place outside of a weekend or a weekday. or they just don't have capacity to be able to deal with that. So the playing field has really changed. And it's interesting to see how that trend has taken place in the court and what people can expect now. But I often say to parents, because I'm a mother, I have children, what you think today might not be what you do tomorrow, and who you are today might not be who you are tomorrow. And working with your co parent and having flexibility for your children is absolutely paramount in getting the recipe right for what a parenting arrangement looks like. And we know that children thrive when they have liberal access to both parents who show a unified and connected front in front of the children. They might disagree behind closed doors, and that's completely fine. But if the children know that they are loved and they have a base between both parents and they can speak to mum and dad freely about anything, that is the best working arrangement if it's appropriate and safe to do so for children.
Basically 50-50 is out. My understanding was that it actually had come in really because of a bit of a misinterpretation of the original rules. Is that right?
I wouldn't be surprised. That seems to happen quite a lot in the family law space. But can I say, I think what had happened is there was some social science research that was floating around for a while, which talked about 50-50. But that research really spoke about that being appropriate for parents who got along really well, who were able, when they hit a road bump, to say, okay, we're going to park that, we'll come back and we'll revisit it, are able to really be in tune to their needs, their co-parents' needs, their children's needs. And when that became a bit of a platform for everybody, you can imagine that not everyone was going to fit that requirement. So what we then saw was the social science pulling that back and saying, actually, that doesn't work for children. And if you don't fit in that mold, it's actually really, really detrimental to the children's well-being to be pulled between houses each week, to not have a place where they call home or a primary base and to spend time with base. And that was really impacting children who were going through separation. So that is now being pulled back, thankfully.
Yeah, I have to say, as a doctor, I navigated this a lot of time, particularly with slightly older teens, and a few cases really stick in my head. Of kids who were trying to do their HSC and they were having to keep moving every Wednesday. They had to keep moving house, and it was awful. And I kind of really did think that this really is not in this person's best interest. And sometimes we were able to get both parents to agree that, that the child would just stay at a primary base and just visit. But we had other situations where the other parent would not agree. And it really was so distressing for that teen to have to move back and forward all the time. It was really, really hard to watch. I have to say, as the doctor, I found it really upsetting.
Of course. And I mean, think about it on the other end of the spectrum. We have little toddlers, kids who are 3 and 4 who are still just developing their own identities, and they've got that primary attachment to someone who, for a while, was being carted between different houses and they were away from their primary attachment figure for long periods of time. It really doesn't make sense for most families and for most children for that to happen. And the conversation that we need to be having with those parents are, it doesn't mean that you don't have a great relationship with your children. It doesn't mean that you can't see them for small burst periods of time where you might go to the park or read stories or be involved in bath time or go to dinner or go to, tutoring, all those things that we do for our children. But it just means that where they lay their head, where they identify as their home, is that safe space. It's their connection for them. And that's not a reflection of their relationship with you, and it doesn't hinder or impact that relationship with you at any stage.
Yeah, absolutely. And so, on that note, for people who are worried that their separation might damage their child long term, and therefore maybe they should stay in an unhappy or difficult relationship, what does the research say about that experience?
This is a really hard conversation that I need to have with parents, because I'm saying for the kids, more times a day than I can count. And I'm sure you as a doctor have heard that as well when people have come to see you. The research around children who stay in high conflict families for 6 months or longer is actually that it impacts their brain development. So we see their brains at smaller sizes than children who are actually in relationships or in households where it is harmonious. And that is a really horrible thing as a parent to hear. The research demonstrates that those children who stay in environments of high conflict for that period of time are at risk of homelessness, that they carry on into relationships later on in life which are unstable, that they have difficulty making choices, that they often develop anxiety and other mental health issues associated with their nervous system constantly being on. That situation is far more detrimental than children who can navigate a separation where both parents are relaxed in their home environments. They're no longer in that toxic environment where both children feel loved. They may not be co parenting, they may be parallel parenting, but it is done in a way where the children are not exposed to conflict. And that's exactly what we need. So we know that those children actually go on to thrive when they're removed from those situations. But it is often the ones whose parents have chosen to stay together for the sake of the children, but the relationship is just horrendous, that actually end up in a far worse position.
And I suppose the other side of that is, can we talk a little bit about sort of the emotional and legal issues of two people who are potentially separated but who've decided to stay within the same home?
Yes. I think the issues around that are definitely financial issues. So, when we've got people who what we call living separated under one roof, it becomes really messy around the finances. Who's paying for what? Arguments left, right, and center about whose things are where and what section of the house you can stay in. There are other issues around maintenance. So, whether or not someone was maintaining the other person, there's issues around, excuse me, contributions with respect to the household. Off the back of that, we have concerns always in my mind around whether or not there's family violence being perpetrated under the household. And for a long time, people thought that meant touching of another person. But we now know that that includes emotional abuse, physical abuse, financial abuse. And a lot of people, particularly women, shockingly, have lived in an environment where they have been subject to that level of abuse for so many years that they have normalized it. And when they're spoken to about it, they don't even recognize that that was really horrendous, unlawful, inappropriate behavior. So, that in and of itself comes with its own complexities. I don't think the financial crisis is doing anything to be able to help anyone in that regard. And I think we need to be talking a lot more about when you do have to live separated under the same roof as someone, what measures need to be put in place to make sure that you are safe, both physically and psychologically.
And so, what kind of measures can someone have put in place if they're in that situation? Because, as you say, with the financial situation for most people, is a lot of people cannot afford to leave and be and get another rental, just not feasible for them.
So they need to really understand separating the finance is absolutely essential at that point in time, particularly having an access to resources if they did need it in an emergency situation, if they needed to leave. Being able to identify what it is that you're contributing to and making sure that you have records around that is really important. Then, off the back of that, also understanding the behaviors that are going on in the household and understanding whether or not they fall within the definition of family violence and ensuring that you have somewhere to retreat to in the event that you need that safe space. Having a conversation with external people who can be the support people around to support you through that process. Understanding that when you disagree, that you need to have a mechanism in place as to what it looks like when those disagreements arise. Are you the type of person who needs space? Does the other person need to resolve it then and then? Okay, if that's going to happen, what do you need to do to make sure it's a harmonious existence? What are the ground rules? And once they're in place, and if the right people have the emotional intelligence to be able to stick to those ground rules, it can be a tenable situation.
As someone who went straight from pregnant to menopausal very quickly, my skin really, really deteriorated quite rapidly. Now, I'd always had a sensitive skin, but my barrier function deteriorated and I developed really very obvious rosacea. And this is something that I see day after day in my clinic also. So many of you reached out and asked what I recommend and why. I have to say that since I opened my clinic, I've been using a brand called Rationale. They're an Australian brand that have been around for about 30 years. And what I absolutely love about Rationale is the products. They feel very luxurious, but they're extremely scientifically derived. And they've got these ingredients called skin identical formulations. All the ingredients, the minerals, the vitamins, everything that's included, the proteins, the lipids have all been found naturally within the human body and therefore they're recognized by the body. So the ingredients are really, really well received. I find that menopausal skins and perimenopausal skins are dry, irritated, and sensitive. And with this range, I'm able to create a bespoke skincare plan for my patients. If you're interested in getting some of these amazing products, head to rationale.com and use the code YOU at checkout to receive some exciting bonus samples with your order. And Cassandra, whenever we talk about finances, it seems that money seems to be at the root of a lot of relationships breaking down in the first place.
Yes.
Arguments about money, how money's spent, if there's enough money, what the level of debt is, seems to be a major issue for a lot of couples. But then moving forward in that separation process, it does seem to me, from what my patients tell me regularly, is it seems to be the biggest bone of contention as well. And of course, it's always nuanced. There's always individual cases, but there is often a real power disparity between someone who's maybe worked part time or had long breaks to raise children, who suddenly finds themselves thinking, well, what am I going to do? And actually, someone else has got all the superannuation and someone else has all the access to the money. And they find themselves thinking, well, I don't even know whether I would have enough money to even have a deposit for a rental, never mind to pay for one. And I know obviously you're Australian based, but where does that all stand?
Look, in Australia, particularly under the Family Law Act amendments that we have here, those people are vulnerable people, and there are things that we can put in place to get them access to money. There are things that we can put in place, obviously, when the asset pool allows for it. I can't pull from nothing, but if it's the case that we have access to resources, absolutely. We can put measures in place for maintenance if one party has the capacity and has, during the course of the relationship, maintained the other party. We can put measures in place around that. We can be making sure that assets can be sold to give people interim relief. So, all of that is available to us under the Family Law Act. But you are right. The main issue that people end up in litigation for is money outside of parenting arrangements. And when those things arise, often what I'm telling people is to make sensible commercial decisions. That doesn't mean you're going to agree with them. It doesn't mean you're going to love them. It means that my rule of thumb is if you can live with it, if you can sleep at night, and you can live with the decision to have taken what you have so as not to have spent hundreds of thousands of dollars or years through the legal system to gamble, because that's really what it is, on whether or not you're then going to get an extra entitlement of money as to what you could have received if you got out early, then that is absolutely my advice. Look after yourself, get yourself out of the process as quickly as possible, and try and think logically, because a lot of people in the legal space are emotionally and principally driven. And that was a really silly position to be in, because they stop making sensible financial decisions and just start litigating on principle. There are no winners in the family law space when that's happening.
And is there a relevance to whether someone is in a married relationship or a non-married partnership? Does that have any relevance to?
No. So now, de facto relationships and married relationships, there are different sections of the Family Law Act. They both do the same thing. And we recognize those relationships now. So people who might come to see me, for example, might say, oh, we've been together for 10 years, but they were never married. And I said, doesn't matter.
What about the situation where you have, it is usually a female at who's stayed at home with younger kids and suddenly find themselves with the partner saying, well, you'll just have to go and get a job now. And the situation is just completely changing. Is that the case that they now just do have to go and get a job or?
Some of the time, yes. Some of the time, no. It really depends on the circumstances. If you've been a stay at home mum for 20 years, you've never worked in the job force, you've got 3 children that are still really young, and you're going to need to raise them for a period of time, then I don't see how there would be any expectation that you could just miraculously get up the following day and go and get yourself a job. Will you need to retrain and get into the workforce at some stage? Yes. But is there a period of maintenance that we can look at to be able to get you there? Absolutely. The other thing that people need to know is those contributions at home are recognized the exact same way as financial contributions in the workforce. Because as we all know, in a partnership, if one person is out working really long hours to be able to financially provide for the family, someone's at home looking after the family. Those two things can't happen at the same time. So the Family Law Act says, yes, we recognize your contributions, but we absolutely recognize the contributions at home and with children. And then there is a financial reward or a benefit that happens for both of those people. So, yes, they could be without super. I think you raised that earlier. The way that we deal with that under the Family Law Act is we want that person to walk away with some of the other person's super. Because really, in order for that person to have accumulated it, this person sacrificed some. So we often see what we call superannuation splits so that everybody can walk away to set themselves up for the future.
Okay. And is that something that happens in a like a 50-50 basis, or is it just very, very individual?
It's very individual. It really depends on the individual case, but most of the time that when I'm dealing with a case that involves super, particularly if I've got one party who's generated a whole bunch of super, the other party's only got a little bit or none, you can absolutely expect that there would be what we call a superannuation split, so as to make sure that that is then evenly, maybe not all the time 50-50, but it is attributed so that some person is walking away with more super than what they did at the commencement of the relationship.
And in terms of if someone finds themselves and they're in a very sort of messy separation and one partner has left and perhaps a partner's still in the family home with children, is there
Yeah.
a period of time that the law says that you've got to be able to continue to live there, or can they be forced to sell the house very quickly, or what is the situation there?
So, no, there's no period of time that you can live in the house. The law basically says if people are separating and that house can't be paid for anymore, then we've got to sell it. Um, Generally, the court won't rush into a decision to do that at the outset because obviously separation is difficult for everybody. And if we've got children involved, we need to look at how we're going to put those arrangements in place. But if the inevitable thing is the house has got to be sold, that you can expect that that's what's going to happen. There are things that we can do to be able to give one person what we call exclusive occupation of the house when there has been domestic violence or family violence and it's not tenable for parties to be living together. There are mechanisms under the law to be able to put that in place. That does not give you a lifelong tenancy. It gives you a tenancy for as long as the house needs to stay in that position until it's sold. And then what we expect is that person could be living there until the house is sold, until they get some access to money, and then they could rehome themselves. Or if there was another set of assets that we had that made up the pool that could be sold early on, that they would then be sold, then people could have some money earlier than when the house was sold, so that if they wanted to move out or if they needed to pay bills, that they had money to do that.
Okay. And in terms of teenagers, sort of being forced to see a parent or whatever, is there an age whenever children are sort of considered that they're allowed to say, well, I do or I don't want to go?
If I had a dollar for every time someone said to me, "Oh, my child is 12, so they get to choose," that used to be the law many, many, many years ago. It is not now. And I have to break that to people the moment they come in. And there was a judge who used to sit on the bench in Parramatta a while ago who had a case where we were dealing with, I think it was a 14-year-old child, and dad was saying, "Oh, but I want orders for him to spend time with me every weekend." And the judge turned around and said to him, "I've got a 14-year-old child. I can't get my child to do anything he doesn't want to do, including get off Fortnite or stop, playing on being on the phone. How is anyone going to force a child of that age to do anything? They vote with their feet." And more the law is realizing that. There is no specific age, let me be clear, where a child's voice is more important than, if they were younger or older. What we deal with is the emotional maturity of that child, and we deal with the individual circumstances of the household. I've acted for children who have been 15 or 16, and the law has said when I've come before the court, this child does not have the emotional maturity nor the psychological development to make appropriate decisions for themselves because of who they were as an individual. And yet I've acted for other children who have been 10 and 11, where the court has said, this child is so emotionally mature that if we didn't listen to their voice, that we would be doing we would be doing a great injustice to them. So it really is quite nuanced now. And it really does depend upon the child. But with teenagers these days, thankfully, most parents are coming through and realizing that even if I got you orders, they're just a piece of paper in the end. If that child doesn't want to do what they don't want to do, No one's going to, come and pick them up and throw them in the car. It just won't happen.
Yeah, absolutely. And in terms of if you have a situation where there perhaps has been domestic violence towards a partner, um but no apparent violence towards the children, but the abused party's clearly concerned about their children going to be with that ex-partner. Is that taken into consideration, or is it a simple case of, well, there was never any violence towards the children, so they have to go kind of thing?
Again, a very nuanced situation depending on what's happened in the family. But the way that violence is looked at is whether or not that violence is a risk to the children, whether or not the risk to the other party then presents a risk to the children, because if that person can't parent appropriately because of that, how does that flow on to the children? We know that violence extends beyond that physical touching. So whether or not it's safe in the other person's household with the things that they're saying, with the things that they're doing, um, what they might be quizzing the children about, all of that is looked at. The difficulty is there needs to be a period to be able to demonstrate whether or not that risk actually exists. And sometimes it's not enough for there to just be a question of, well, did it happen in the relationship? Okay, well, it might have, but what does it look like now? Because sometimes what we deal with situational violence, and that is the toxic bringing of two people together where it was just not tenable for them to live in the same space. And with all of the different things going on in the relationship, that created an environment that was really just not appropriate for them to be in the same space. And sometimes when that relationship ends and they're no longer together and they're no longer under all of the pressures that they have, that violence goes away. We're not talking about physical violence. We're talking about that perceived level of emotional abuse and things like that. And when that is no longer in the picture, it may be a safe situation for the children to be in. It may not. We need to look at it on a case by case basis and look at the individuals who are in that space to be able to determine that situation.
And in terms of cultural or religious differences with regards to, obviously nowadays divorce and separation are much more widespread than they were 50 years ago, but there's definitely still cultural and religious nuances within that as well. What would you say to um clients of yours who are navigating sort of the difficulty around the shame and stigma for some communities that there still belongs?
I'm asked this question a lot. Um, I often say to people, you were married to be in a partnership with somebody who was going to love and respect you. That's why you entered into marriage. That's why we all got married. And when that is no longer on the table, there is no shame with you leaving a relationship where you are not able to fulfill the promises that you made to one another. And thankfully, most of the religious sects that we're dealing with now also appreciate and understand that, because it doesn't fit within the model that they would tell people that you are supposed to stay in a marriage where you are being, physically abused, emotionally abused, financially abused. That's just not the intention. So when I talk to people rationally about that, a lot of that shame goes away, because I think what existed, at least in my mother's generation, for example, and my grandmother's generation, was this concept that you stayed married at all costs because that was marriage. And that no longer exists in this generation, and definitely the generation that has come after me, where people are far more comfortable with the idea of, if this relationship is no longer giving to me, that I'm out. And I think that that shame that we used to see so many years ago of, oh, they're divorced now, what a failure, is actually going away, where people are recognizing that people are getting divorced because it's no longer fulfilling them, and the relationship was no longer something that was actually good for them. And that's being celebrated. And I think that that way of looking at it around, we tried everything, and please do try everything. But if it's just not working, then there's nothing wrong with it being the case that you leave. I think that that conversation needs to become normalized.
And in your opinion, do you feel like relationship counseling should be sort of mandatory before people separate, or do you think that it's not an essential step for people?
I think relationship counseling is a fantastic tool when I have somebody who is there for the right reasons. If you are turning up to relationship counseling under duress and don't want to do the work and are not emotionally intelligent, are not there to be attuned to your partner's needs, to want to fully commit to it, I think it is a waste of time and money for people because it sets unrealistic hope for the person who is there for the right reasons. And it also then just creates an extra thing for them to argue about. And that's often what I tell people. If you think that the marriage is worth saving and you're willing to do the work, get in immediately and get yourself a great relationship counselor because that can be the thing that puts you right back on track. But for some people, it's just prolonging the inevitable. And if your partner really doesn't do any of the homework, and the right relationship counselor generally calls that pretty quickly, that they see what goes on in the space and they say, actually, you guys don't need to be here. Please just go and separate. I think that people just need to be honest with themselves about where they sit in that space.
And are there any tools or books or resources that you would direct your clients to that might be helpful to our listeners?
The Gottman Institute is an incredible resource. I love all of their
Oh, I
materials.
love those two. They're
Just
so good.
so good. I mean, I still use them on my husband today. It's fantastic. And I think when you're married for so long, it becomes a really simple thing to fall into the pattern of we actually don't know how to speak to each other anymore because all of our conversations are about the children or about the finances or about all of the adult responsibilities, and you forget how to be a couple. So they're amazing. I think there are also some really good resources that actually sit on the Family Court of Australia website, or it's now the Federal Circuit and Family Court of Australia website because we needed to make things longer and more difficult. But there's free information that sits there that people can read about the process. What do they need to do? What are the first steps that they need to take? I wrote a book for people that they can download from my website really cheaply. I think it's on Amazon for like $2, where it sets out the process of what a dignified divorce can look like, how to keep yourself out of court. If you're thinking about separating, you can download that and just work through some of the things that are in there to be able to set the tone for an amicable separation. There are some really amazing resources that sit on the 1-800 Respect or the DV website of Australia that you can actually go to get some information about domestic violence and what that looks like and tapping into some of those services. So I think if you're looking for information, it's there. It's just knowing what you're looking for and the reason that you're looking for it. What outcome do you want as a result of it? Do you just want to arm yourself with information? That's completely fine. Are you ready to take the next step? Or do you just want to be in a situation where you talk out what's going on with somebody as well?
If a couple are separating, that they have a mediator or a third party witness if they're trying to work through and come, to their own sort of agreements. Do you think it's worthwhile having a third party agreement or recording conversations, or or how legally binding are agreements if there is no legal personnel involved?
Well, it's very interesting because we just saw a case come out a few weeks ago that I'm following with great interest around an agreement that these two parties had done that normally would not have been binding, but the court has actually said, yes, it was binding. Um, so that situation is kind of changing and it really depends on the intention behind it. What were they intending on doing? What was the mechanism for that agreement being put in place? It's really helpful to have a mediator. If you can't agree on something and you really just have exhausted the conversation between yourselves, it's really helpful to have somebody in the space who can think about things in a way that you might not be thinking about them, but also to hear the communication that you're trying to get across that isn't landing on the other person. And most of us who work as mediators in that space have a specialized skill set around communication, whether it's verbal or nonverbal, and really hearing the messaging behind what might be coming out of someone's mouth. Because sometimes the intent and the words don't align. But we can actually see what the root cause of things are, and we can see what the intention and the problem is. And when that happens in mediation, it's a really beautiful thing to watch because for the first time, you see it land on the other person and they're like, oh, actually, that's what this is about. It's not what you've been saying the whole time. It's about the fact that what you actually needed was an apology, or what you needed was to know that your future is secure and that you're not alone in this space. So I can't impress upon people enough the value of getting a really, really good mediator and just trusting the process around that and being able to then walk away with an agreement that you have come to and that will stick because you've actually agreed to it, but with the benefit of a third party person.
And how does someone find a really, really good mediator?
Yeah, it's a very good question. A lot of us who work in the family law space have relationships with mediators that we have built up that we trust because we work with them every day. And the best recommendation can come from somebody in that space when they know what the communication style is between you both, what the issues in dispute are, and what it is that you hope to achieve. Because different mediators are for different people. Who I am as a mediator is different to who I am as a lawyer, and that won't fit everybody. So once you can break down that, you can get a really great referral to people. And once that happens, sometimes we might see people 3, 4, 5 times over the course of their separation for one thing only, or for 6 things that have arisen. And it keeps them out of the court space, and it's fantastic.
Yeah, absolutely. Cassandra, one of the things that patients have said to me a number of times over the years, whenever there has been a third party involved, and there's often a lot of hurt and betrayal and upset, but the the party who didn't have the affair is feeling very wronged by the situation and therefore kind of wants some kind of acknowledgement by the court process or by the legal process that there is like some kind of additional payment for their pain or for the fact that they didn't do the wrong thing. And I my understanding is that that is not taken into consideration at all. Is that right?
That's right. In Australia, we have a no fault divorce system here. So it is horrible that your relationship has ended that way, and that is a huge breach of trust. But we don't recognize that from a financial perspective at all. In the US, it's different. In fact, I think from August in the US, there can actually be a breach of contract when you cheat in your relationship, which is a very interesting thing to happen. And I'm wondering if that will come to Australia. But at the moment, the circumstances in which your relationship ended will not get you an additional payment if we're talking about infidelity or if we're talking about, um, there being a breach of that trust.
And I think that's really hard for people to get their head around because a lot of people are understandably stuck in feeling very hurt, betrayed, upset, and they want some type of what's the word? Like payment or someone to, in some way acknowledge that they get something to pay back for what's happened to them. And I find that people can end up really stuck in that for a long time.
Yes, and, I've had people come to me with grocery bags filled with receipts around infidelity, and I have to say to them, "I'm so sorry. I can't do anything with that." And I hear you, it is horrible, but from the law's perspective, we're here to be able to just deal with the separation, and that is what do we have to separate, and how are we going to separate?
Pets is definitely one that seen patients really, really struggle with. I've I've had a situation where definitely a partner who was not interested in the pet at all made it their absolute mission to get the pet from the person who loved the pet. And definitely pets can be as emotionally charged as fighting around children. Where does the law stand with pets?
On the 15th of June, we finally got an amendment to the Family Law Act to deal with pets. So, if we are talking about an emotional support animal, and that animal does not have anything to do with a business or have any other role, the court can now make orders with respect to that animal and see that travel between different households for a parenting arrangement. we can now, as at the 15th of June, deal with other types of animals who might be involved in a business and the like, be put on a balance sheet as an asset. So we can deal with the sale of that animal, whether or not it's worth something, whether or not someone's going to keep that animal and to what value they're going to keep it. That's a very different playing field to what we've been dealing with for many, many years. Now, if it's the case that this animal is not an emotional support animal and it's got no value, well, we're still in a land of limbo around what we can do with that under the Family Law Act. And I'm sure with time and with all of these cases that are now going to be coming through the courts that will be guided with some additional case law, which would be a very welcome situation for us in family law. But the fact that we can now, particularly for neurodivergent children or neurodivergent adults who are using those animals for support, it is a very welcome change.
Actually, just mentioning neurodivergency also triggered an issue that I see repeatedly happening, which is one parent not believing a diagnosis of maybe ADHD or ASD, and that parent refusing to either let the child be medicated or refusing to engage in therapies such as psychology, occupational therapy, and it all becoming incredibly stressful and traumatic. Where does the law stand with that? Because there
That's a
does seem to be a
capacity
lot of
issue.
confusion.
Yeah, absolutely. No, that's a capacity issue. Whether or not I've got a parent who can actually do what is needing to be done in accordance with a diagnosis goes to whether or not you can appropriately parent your child. It goes to the issue of parental responsibility, whether or not you're a vehicle to make long term decisions for a child who is experiencing a diagnosis. The difficulty for many parents, and I think this is something that should be spoken about, is there is a bit of grief that comes with a diagnosis, particularly when you haven't anticipated it. So I have a child who is neurodivergent. I remember that process of having him diagnosed. Um, and just that process after a while of dealing with family who couldn't understand that that was a possibility. And we faced a lot of backlash as parents around, oh, why would you get him diagnosed? Why, like, that's not a thing. That's not real. That whole cultural thing that comes with it. And understanding the difficulties of dealing with that from a separation perspective is very hard. But the way that the court deals with that is to say, well, if you can't follow through with that, well, maybe you're not the right person who gets to make the long-term decisions for that child. And if you can't medicate your children in accordance with the direction of a health professional who has appropriately assessed this child, then maybe you're not the person who gets to spend time with that child on the times that that child needs to be medicated. So it is quite a serious issue. And it is something that the law deals with, I think, quite well. What there needs to be is established evidence around those things, and getting the medical professionals to make sure that they put an evidence around that is a really helpful thing that people can do to make sure that they're then able to satisfy a court of those things.
The reputation in Australia of the family court, in my experience, is not great in that people don't often have a lot of very positive things to say about the family court system. They'll say about how long things take, how expensive it is, how at times there's been very high profile cases where decisions have been made to allow, for example, violent men to have access to children that has ended extremely badly. Um, where are we in that process of trying to modernize and make the family court a much more evidence-based place that people can feel more safe and secure in the decisions that are made by that court?
I think our Chief Justice is doing an incredible job around that at the moment. These amendments that are coming in are really, really important amendments. Things what used to take a very long time. So I've been doing this job for a while now. We used to be in the family court for anywhere between 3 to 5 years. That doesn't happen anymore. We really see cases settling within 12 to 18 months. Is it still expensive? Yes. It depends also, though, on the way in which people engage in their litigation and also the way that their spouse engages in their litigation. So if I have two sensible people who can't make a decision on something but are really being really quite cost conscious and appropriate in the way that they engage in themselves, then they're going to get in and out really quickly and much cheaper than people who are in there litigating on principle. And the court is cracking down on that. The court is cracking down on people who are filing applications who have no merit. They're cracking down on practitioners who are allowing cases to be run that have no merit. And there are costs that are being ordered now more than ever before against those people as a deterrent to make sure that they do not end up in that space. I think the court is doing a much better job around family violence than it ever has before. And we now have all of these different models in place to collect information that we never previously had and to bring in people and professionals into the space in a way that we've never seen before to be able to get that evidence before the court. As a litigant, it is absolutely crucial that you are communicating with those people and with your lawyers the right information. Sometimes it is very hard as a family lawyer to elicit information from people because we hear all of the irrelevant things. And then sometimes we can be 10 months into litigation and your client will turn around and tell you something and you say, that that was something you should have told me 10 months ago. What do you mean that you were going through this and you never said anything? And they might say, oh, I forgot, or I didn't think it was relevant. But you came in with 3 grocery bags of receipts about the affair, but you didn't tell me about that thing. Like, that's what I need. And understanding what is expected around disclosure, making sure that you're organized in that your thought and process and working with a psychologist in the background to deal with the emotional aspect of separation, which is a big, huge component of it. But knowing who the right people are to talk about the different things in your separation will avoid you spending hundreds of thousands of dollars to talk to your lawyer about how aggrieved you feel about the process when we can't do anything about that. What I can do is try and get you access to money, to try and get you out of the process as quickly as possible, to get you parenting orders, to get you an order that keeps you safe. Absolutely. But I can't really unpack that emotional burden with you. That needs to be done elsewhere. So I think with the right process in place, the court is a really helpful tool. And we have really recently used the court as a really successful model for getting people in and out of the process quite quickly. But it also can be done very badly. And those are often the people that you see quite aggrieved with the outcome.
And in terms of, I don't know what you think about the term parental alienation and whether you think that's a thing or not. I know that that can be up for debate, but what do you think about those situations where there is one parent who is potentially, you know, convincing children not to see another parent, or just constantly putting roadblocks in the way so that, for example, the access is just constantly not happening, and the other parent is just finding themselves having to constantly spend huge amounts of money trying to gain access to their children.
It's a huge problem. I think alienation is very real. And we now have processes in place in the court to identify that early. Thankfully, not with lawyers, because that's not our role. We should be identifying that. But with people who are psychologists and psychiatrists and social workers that are attached to the court or are working with the court to really get to the root cause of that and to also identify it. And with the court's intervention early on, that can be turned around. But if you're somebody who's let that go for many, many years, good luck trying to undo that once it's happened, because the practical effects of getting court orders for a child who has been alienated, who is not going to then come back, is a waste of your time. What we need is proactive intervention early on. And what we need is to be able to identify that and sometimes it's not being done maliciously. Sometimes it's being done from a situation that is very real to one party, but also they need intervention, and they need intervention quickly in order to prevent that behavior from continuing to escalate. So again, it's about actively doing something about that as a parent who's on the other end of that and making sure that you get the right measures in place to undo that or to prevent it from happening as soon as possible.
And I've also had a few situations where one party refuses to either communicate and won't communicate through lawyers. So you've got one party who's got a solicitor who's sending letters and they're just being constantly ignored. And the other party just refuses to engage, get legal advice. And and this person's over here, and they feel like they're spending a fortune having appointments, having letters, relentlessly written, but getting no response. Is there a legal bit where you get to a line in the sand where the person is forced to engage, or
My question is, why are we sending letters if we're not getting a response?
yeah.
When
I've
is
seen it
enough enough?
happen. I've seen it happen quite a few times.
I'm sure it does, but thinking about this from the perspective of the client, and that's really what we should be thinking about the whole time as lawyers, is what are you trying to achieve? If you're conducting litigation by way of correspondence just for the benefit of writing letters, then you're not doing your job. If it's the case that you're doing it for the sake of trying to establish the pre-action procedures that we're required to oblige, we're required to adhere to, let me speak properly, then sure, one or two letters, no problem. But then file and get somebody who has the authority to get this person to engage to do what they need to do. And if they don't, then the matter's going to run undefended and you're still going to get what you want, but you've done what you needed to achieve the goal of the client. If you're just simply writing letters for the sake of writing letters, well, you're not exercising a legal function, you're a postbox.
True. Okay, thank you. That's really interesting because that's definitely something that a few patients have discussed with me and been really very distressed about. Now, Cassandra, you have a retreat that you have organized that people can go on in Sydney. Can you tell me a little bit about that?
Yeah, I founded Australia's first ever divorce retreat, and we've done many of them since then. It's just a really beautiful space where women can come and connect with other women to talk about their experiences, to build community, to get some access to professionals that they previously might not have been able to afford to get under the same roof, to be able to share very vulnerably about their concerns for the future, to talk about their own experiences of being in a relationship where they didn't feel loved or wanted, and to be able to put measures in place to be able to feel like that won't happen again in another relationship. Really, I started it for myself, to be honest with you, because doing family law work, we see the worst of humanity. We see the worst of what people are going through. And when I run those retreats, they're really joyful. It's really beautiful to see the connection in that space. I get to wear a very different hat to what I normally do when I'm being a lawyer, and it's very human driven. So they're just a really lovely thing to do. I love them.
Yeah, it's amazing. So, how would anyone listening be able to find out a little bit more about those if they wanted to explore that?
The best thing they can do is send an email to my office, which is legaladmin@kalpaxislegal.com.au. We run mini retreats throughout the year. We run big retreats. It really just depends on where we're at in terms of what's going on in the world and also what we're permitted to do here and how many interests that we've got. I think this year we're talking about running another one in Byron, which will be really beautiful in November, so that women can just come and spend the weekend, really just nourish themselves. And it also is a really nice excuse for me to be up in Byron with some people that I like hanging out with.
Cool, that sounds amazing. And can you tell us the name of your book that we can find on Amazon?
Yeah, it's called Dignified Divorce.
Okay, amazing. What's the one thing that you wish every couple understood when they begin the separation process?
How you engage at the beginning of your separation will determine how your separation will travel for the balance. If you go in aggressive, if you go in making demands, if you are being really obstructive, please expect that that is how the rest of your divorce will travel.
Yeah, true. And what about, I've had a few recent encounters with women who are in the middle of very toxic divorces. And I don't want to overuse the word um, dissociating, but nearly whenever it comes to any type of engagement with legal people or whatever, they just don't seem to be able to do it. It's like they're nearly like a complete bury their head in the sand. It's all around them. It's all kind of going to the dogs, but they are so overwhelmed that they just seem unable to answer the phone or reply to an email or to send off the information that they need to send off. And it's so hard to get someone in that situation because of course I'm feeling so compassionate for them, but I'm also frustrated because I'm thinking if you could just do that thing, this would all move forward. Do you have any words of advice or suggestions for someone who just is feeling so stuck and overwhelmed that they cannot do anything?
We get that a lot. The best place that or the best thing for people to do is get yourself some support people that you trust that will look after you to come to appointments, and they'll create an action list and they will tick it off with you. That we do what we call a weekly Teams meeting. So we won't call you during the week unless it's urgent so that we're not overwhelming you. We'll have an agenda. All we need you to do is get on that Teams meeting with your support person. We'll hash through it and get it done. Sometimes I say to people, I don't need you to respond to correspondence that I don't need you for. So if it's procedural stuff, do I have your instructions if it's procedural to do X, Y, and Z? And they'll say yes. Um, is it the case that you don't want me to respond to things that don't need responding to? Sometimes I just don't need to respond to a letter that is stupid or doesn't do anything to advance the matter. And they'll say yes. It's really about working with the client and what it is that they're trying to achieve as part of their separation and not making their life harder. So sometimes if I've got someone on the other side who I just think is there really to just be a mouthpiece for their client, I will say to my client, what I propose to do is send this response. Are you okay with it? And they'll say yes. And I'll say, sorry, we don't need to respond to that. Please tell me how this advances the matter at all. Please tell me why this requires a response because it doesn't fit within X, Y, and Z of the Family Law Act. And that often makes them go away. And my client didn't need to feel overwhelmed by it. If I've got a really horrible letter that comes in at 4:53 on a Friday, because it's always 4:53 on a Friday, I will tell the other people, sorry, my client's not getting that until 9 a.m. on Monday. And then I will call them and say to them, correspondence has come in. I'm not sending it to you today. Enjoy your weekend. On Monday morning, we need to workshop it together. I need you to come in. I will have a response prepared for you already so that together we can then just go through and send it off instead of me flicking it to them and saying, oh, I need your response to this. Get it to me on Monday. And they're like, well, this is horrible. Why would I want that? So know who you're working with and know what they need.
Yeah, amazing. Oh, I've absolutely loved this conversation. I think that you seem to come at things in such a fantastic and really innovative way. And I do think that not all lawyers are like you, which is but I think you're definitely a bit of a trailblazer. So if someone wants to get in contact with you, just remind us again what the name of your business is.
Kalpaxis Legal. We're on the web. You can email us at legaladmin@kalpaxislegal.com.au. And we do all of our appointments that way. So that's the best way to get in contact with us.
And are you, the way the rules work, are you New South Wales based clients only?
No, the benefit of the Commonwealth Family Court Act is that we have clients all across Australia. In fact, I've got clients in the middle of France at the moment. I think one is in London. So we're not really dependent upon where you are. We actually do quite a lot of work everywhere.
Okay, amazing. And my final question, which I ask all my guests, is if you could tell 20-something Cassandra something, what would you tell her?
You do not need to do everything. Do one thing and just be good at the one thing. Your worth is not dependent upon how productive you are.
I love that. Thank you. Thank you so much. That was great.
You're welcome.
This podcast and any information, advice, opinions, or statements within it do not constitute medical, healthcare, or other professional advice. Information is provided for educational and entertainment purposes only. If you have any health concerns, always consult your doctor.